Most people think getting long-term disability benefits is about proving you're sick. It's not. It's about proving you meet the policy's definition of disability in writing with the right evidence at the right time. Hi, I'm Brandon Osterbind, and I'm an ERISA disability lawyer here in Virginia, and I make videos to help disabled people understand their rights. If you clicked this video, you are likely trying to get benefits or you've already been denied. I know this could be a stressful and confusing time. Trust me, I know. Our team helps a lot of people with these things every single day. Well, worry no more, because I'm going to walk you through what it actually takes to get long-term disability benefits approved. No shortcuts, no tricks, what the law actually requires. So let's start with the foundation. Most employer-provided long-term disability plans are governed by a federal law called ERISA. ERISA stands for the Employee Retirement Income Security Act. It was passed by Congress in 1974 to regulate employer-sponsored benefit plans, including retirement plans, health insurance, and long-term disability insurance. Now, what this means for you is this. If your disability policy comes through your employer, it is almost certainly governed by federal law, not Virginia insurance law or by their one-man HR team. Under ERISA, the insurance company's decision is based primarily on what's documented in the administrative record, not what you say later in court. That distinction matters more than most people realize. Now, under ERISA, disability claims are evaluated based on two categories. First, the language in the policy, and second, the medical evidence in the file. That means that there are three things that matter more than anything else if you want to get benefits. First, you must meet the policy definition of disability. Every long-term disability policy defines the word disability. Usually it starts as unable to perform the material duties of your own occupation. Later, it'll likely shift to unable to perform the duties of any occupation. That definition controls everything. It's not how you feel, it's not how frustrated you are, it's not how unfair it seems. The question is always, does the medical evidence prove you cannot perform the duties as defined in your policy? And if you don't know what your policy says, you are guessing. Second, your doctor must support functional limitations. Diagnosis alone is not enough. Saying I have chronic pain or I have depression is not sufficient. Insurance companies always look for specific work restrictions, measurable limitations, functional capacity evaluations, and consistency in your medical records. If your doctor notes say things like doing okay or stable or no restrictions, your claim will almost certainly be denied. You may think I'm joking, but I have literally seen records that include one-line notes with zero context. It's awful. Under ERISA's claim regulations, specifically 29 CFR section 2560.503-1, insurers are required to conduct what's called a full and fair review, but they're allowed to rely on the medical evidence in the file. If the file is thin, if the file is inconsistent or unsupported by functional proof, they're going to deny your claim. So step one is not arguing with the insurance company. Step one is making sure that your medical documentation matches your occupational reality. The third thing, timing and record building matters. Here's something most people don't realize. In ERISA cases, if your claim is denied, you typically have 180 days to file an appeal. And that appeal is not just a request to reconsider, it's your opportunity to build the administrative record that a court will later review. After that appeal time period closes, you usually cannot add any new evidence. So getting long-term disability benefits isn't just about filing a claim, it's about building a complete record from the beginning. That means updated medical records, clear treating physician statements, objective testing when appropriate, and documentation on how your job actually functions. Because the insurer is not evaluating your suffering, they're evaluating your proof. So let me simplify it for you. If you want long-term disability benefits approved, you must know your policy definition, align your medical evidence with that definition, and document any functional limitations clearly and consistently. Protect your appeal rights if a denial happens. Don't waste your one and only appeal. There is no shortcut around those things. The law does not require the insurance company to believe you. It requires them to review what you have documented. If you're unsure whether your medical records support your claim or whether your policy definition has shifted from own occupation to any occupation, that's not something to guess about. Understanding those rules early can prevent a denial later. If this video has been helpful, do me a favor and subscribe to our channel. And before you go, make sure that you watch our video, What Happens If My Doctor Says I Can Work? Even strong disability claims can fall apart if your treating provider isn't documenting the right restrictions. And knowing how to handle that situation can make the difference between approval and denial.